So the appellant who has been convicted under section 302, sentenced to go high for life. He is in custody, my lord, since 27/11/13. So more than 8 years now, my lord, he is in custody. The last order was order number 4 and order number 6.
मिस्टर ठाकुर, ये केस हम नहीं पढ़ पाए थे, क्या इसमें क्या एलिगेशंस क्या है? व्हाट इज द फाइंडिंग ऑफ द ट्रायल कोर्ट?
Trial court finding are twofold. Lord, for the first time, PW 5 and 6, they are naming.
How many appellants are there?
No, single, sole.
Sole appellant.
Yes.
There are other appellants also.
No.
He is the only person who has been convicted.
Yes, he was the only person who was put on trial. Just. Yes, he was the only person who was put on trial and was convicted. There are two types of evidence. Firstly, for the first time, PW 6 and 7 is naming this appellant during trial. They have not named him either in 161 or 160.
Was there any eyewitness?
PW 5 and 6.
They are eyewitness.
They are claiming to be during trial to be an eyewitness, naming this appellant for the first time.
Yeah, in which manner he was killed?
Milord?
In which manner deceased
Milord,
was?
it is alleged that the deceased was working, Milord, in a party or which are being organized, and the appellant was not liking her to do that work. He was asking her not to go in those party work and other things. And for that reason, this occurrence has allegedly taken place.
So how he was assaulted?
Firearm injuries are there.
Firearm injury.
Yes. Now, second, Milord, is dying declaration. These are the two materials which is, Milord, against the appellant. So far as dying declaration is concerned, Milord, we have challenged that there was no RTI. And
in dying declaration, he has named appellant.
She has named the
तब क्या वजह है इसमें?
जो है होता ना डाइंग डिक्लेरेशन में हजूर ये है 2-3 चीज
कितना देर से जेल में है?
ये हजूर कस्टडी में है 27/11/13 से मोर देन 8 years.
More than
8 years.
लाइफ इम्प्रिजमेंट है
जी, लाइफ इम्प्रिजमेंट 8 years से ज़्यादा हो गए. डायग्नोस्टिक का तो ये हालत है कि ना जो नर्स का अटेस्टेशन है, ना डॉक्टर का सर्टिफिकेट है. वी हैव चैलेंज ना जो अटेंडिंग
How many injuries were there?
that one we will get from the judgment.
How many fire injuries are there?
Not that I'm just Lord, it is alleged from Lord Sunny.
It is to be seen whether it was on account of sudden provocation or it was a pre-planned murder.
No, it was sudden because it appears that the girl and the boy were in love with each other. The boy was not liking the girl to work, Milord, in the party which was being organized, Milord, by the others, marriage party and others. He was asking, and he was with another person in a hotel where, Milord, this incident allegedly took place, where The Sunny alias Saurav and this Pratibha both were shot at. The deceased Pratibha has received one bullet injury, whereas Sunny has received two bullet injuries. Initially, Myloard, this appellant was not named. Even in 164, no witness has named him. During trial, for the first time, Myloard, PW...
In FIR, he was not named.
Not named. And then, Myloard, in 164 also, he was not named by any witness. During trial, PW 5 and 6
But you said that in die integration, he has been named.
The IO CW1 says that one day after...
Who is the informant?
Lord, first informant, Lord, is Lord, the relative of the deceased, PW4 Vijay Prakash, alias Pappu.
The statement of 164 has been recorded by
the London Judicial Magistrate, Lord, of PW5 and 6.
In that also he has not named.
In that also, Lord, the appellant was not named. That
both claim to be eyewitness.
Yes, and then during trial for the first time they are naming this appellant. Page 5 of the judgment, Myloard, you get it.
After how many days he died?
Lord, it appears, Lord, that Lord, there are 2 deaths in the present case. One dies, Lord, on the date lodging the FIR. Another, Lord, after 2 days.
It is a double murder then.
Yes.
Mr. No case for grant of bail. 2 eyewitnesses, 2 are naming your client. Your presence of your client is there. You fired at a boy and girl sitting in the cafe.
For the first time during trial.
Whatever it may be, it is
Yes.
case of eyewitness account of twin murders by 2 witnesses. I don't understand.
That is what I am submitting, that these 2 witnesses, PW5 and 6,
Yes.
have seen the
Whether
judgment.
their evidence is trustworthy or not has to be seen at the time of the
Because,
hearing of the appeal.
in
But
160,
fact remains that there are 2 eyewitnesses to 2 murders of
Yes.
a girl and boy.
yes,
And without any provocation, case that it is covered by any exception to section 300 of the Act.
To that extent I never said.
Bullet injuries to vital parts of
But it
2
was
persons.
there. What
Just-
I submit that PW5 and 6 from the judgment itself, Myloard have seen that they in their 164 statement which has been exhibited, they have not named this appellant.
Substantive evidence is that of doc identification, and PW6 was knowing your client.
Yes, and then he is not naming me, Myloard, during
Yes.
investigation.
We'll see
Neither
the
in
fact.
161 nor Myloard in 164.
Murder of a boy and girl sitting in the hotel, by intervening, why you are taking services of Pratibha?
That
This question was asked to Sunny, and thereafter Sunny and Pratibha both were fired by the...
appellant.
Yes.
Yes, that is the prosecution.
So,
Myloard,
where is the case for
this
grant of bail?
Myloard, this is not the initial prosecution version. Initial prosecution version, appellant was not named. Now,
Weapon was gun. There was not a whisper of any quarrel during
No,
the course of the incident.
But when the Myloard will see the deposition, that will
Yes.
come. But I am not going on that. What I am submitting, Myloard, that this PW 5 and 6, they are naming this appellant for the first time during trial.
Doc identification is the substantive evidence. Rest of the evidence is corroborative evidence.
Right, Myloard, therefore, that will be for contradiction also.
Yes.
Because the persons, Myloard, who are...
Apart from that, there is dying declaration.
Yes, dying declaration, my lords, have seen that except this IO, neither there is any certificate of doctor, nor there is any certificate
There
of...
is a statutory requirement
No,
that the certificate of
at
doctor
least
should be
we
there.
have see whether she was in a fit state of mind
There
give
are
a
tons
sta-
of judgments of Supreme Court which says that these formalities are by way of precautions.
Yes.
Even if the dying declaration is not supported by endorsement of the doctor, if it is found trustworthy and truthful, conviction
That-
can be based solely on
Basis of that dying
the basis
declaration.
of that
Yes,
dying declaration
but
without there being any corroboration, without there being any witnesses.
Yes, at the first day, my lord, when the FIR is being lost, this IO is there. Absolutely, there is no statement of
Okay,
anybody.
we will see, this is all, this is on merits of the matter.
Exactly.
Without
That
we
is
are
why I am
just for
submitting, my
final
lord, that
hearing.
now he is in custody for more than 8 years.
Mr. You know Sudan Singh, 8 years is not sufficient in twin murder cases. Exceptions are carved out in Sudan Singh case. Gruesome murder, no case of grant of bail, even if 10 years, 12 years, 15
No, it
years.
cannot be said to be gruesome because
That is
my
what
lord-
Supreme Court says, I am not
Yes.
saying. That's all.
Yes.
This is an application for suspension of sentence and for releasing the applicant stroke accused on bail during pendency of the trial. Next para. Heard both sides. Next para. Earlier similar applications were rejected by this court repeatedly. Full stop. Next para. The learned counsel for the appellant submitted that the eyewitnesses are not naming the applicant as the author of crime. Full stop. Dying declaration is recorded without there being any endorsement by the doctor. Full stop. Evidence of the eyewitnesses is untrustworthy and unbelievable. Full stop. The learned APP opposed the application. Next. We have heard the submission so advanced. Full stop. On earlier occasions, comma, the similar applications were rejected on merits, and therefore we are not in a position to enter the merits of the application again without there being any change in circumstances. Full stop. Next para. This is a case of twin murders allegedly committed by the applicant by use of firearm. Full stop. The couple was sitting in the hotel when gunshots were fired on them, causing their death. Full stop. The applicant is stated to have undergone 8 years of imprisonment. Full stop. That itself is not a criteria for grant of bail in gruesome murder of a couple. Full stop. The application is devoid of merit and accordingly the same is rejected.